Hi, my name is Kyle Scoresby. I'm an Arizona divorce and family law lawyer. Um, Often clients come in when they're going through child custody cases and they want their child to be represented by a lawyer. They say their child needs to be heard and they want someone to stand up for their child. Well, the law does allow um, representation of children in child custody cases under certain circumstances. Specifically, Rule 10 of the Arizona Rules of Family Law Procedure outlines three ways in which a child can be represented, quote unquote represented. So the first one is called a best interest attorney. And the reason I put the represented in quotes is because two of these three aren't really representation of the child. Okay? A best interest attorney is a lawyer who's appointed by the court to represent what's in the child's best interests. That may be different from what the child wants. The lawyer's specific responsibility is to represent what is best for the child. So if the child wants to live with dad, but dad is a drug dealer and the child wants to live with dad because there's no curfew and no rules and the child never has to do homework, that may not be in the child's best interest. So the best interest lawyer would report that to the court, and beyond just reporting to the court, would actually advocate for what's in the child's best interest. Now that's different from the second option, which is a child's attorney. That truly is representation of the child. Someone who's appointed as a child's attorney is representing what the child wants, the child's wishes, not necessarily what's in the child's best interest. I just haven't seen those used in Arizona. Those are very rarely appointed. The most common of all is the third one that we're going to talk about, and that is a court-appointed advisor. A court-appointed advisor is usually a lawyer, but can be another professional like a counselor or therapist. Their role is more of a witness. They're not really so much a lawyer, even if they happen to be an attorney. Their job is to conduct interviews, do home studies, visit the parties' homes, and then come and report to the court on what they found and what they believe might be in the child's best interest. They can't advocate and file motions like a court could. They're simply reporting like a witness as to what they think is good for the child. Now, one last thing that isn't under Rule 10 at all as far as representation of the child. Sometimes the parents just want a child to be heard. And it's very common for judges to order, if the parents ask for it, an interview with children of suitable age and discretion. In that interview, the children are able to tell the interviewer what they want and what their concerns are about both parents, and that interviewer can then report to the judge either on a confidential or non-confidential basis as to what the children have reported to the interviewer.